I have the privilege of serving on the board of directors of the Pioneer New England Legal Foundation, and I have also had the pleasure of attending this event for multiple years. It is one of my favorite events that this organization continues to try to put on. For those of you that are new to the Legal Foundation, welcome. We're very glad you're here. For those of you who have been supporters for some time, thank you very much for your continued commitment. It truly allows us to continue to do the work that we do here. It helps hold elected officials accountable to the people they serve. It ensures that every child has access to the high-quality education that is guaranteed by our Constitution, and it protects the rights of entrepreneurs and businesses from burdensome government overreach. Tonight's program was created around a simple but powerful idea that even the most challenging and controversial issues can be discussed in a thoughtful and constructive way. We believe that disagreement does not have to mean division, that respectful dialogue, grounded in a willingness to listen, can inspire greater understanding. In short, tonight we want to model the type of civil discourse that transcends artificial labels and encourages the idea that disagreements are not barriers to a fulfilling conversation. We had it for a second there. My hope is that you leave this evening feeling inspired, with a renewed appreciation of the free exchange of ideas, as well as the rule of law and in the role it plays in a free society. And I hope you'll continue to stay engaged with the Legal Foundation as we expand our work across the region, including the launch of our state advisory councils this summer. It is now my distinct pleasure to introduce to you Chris Dugan and Peter Durney. Chris will be introducing Professor Akhil Reed Amar. Chris is a partner at Smith, Dugan, Cornell, and Golub. He is one of the most accomplished trial and appellate lawyers in the United States, having tried more than 75 cases to jury verdict in federal and state courts across Massachusetts and in several other New England states. His clients include publicly traded and privately held companies, insurers and reinsurers, and individuals in complex, large-risk litigation across a broad variety of matters. Chris founded Smith Dugan with Scott Smith, in 1989 as a two-lawyer practice, and it is now ranked by U.S. News World Report as among the best law firms. Recently, Chris authored an outstanding amicus brief, if we might say so, in Trump v. Barber on behalf of the Legal Foundation, for which we are very grateful. Professor Amar, as well as Vikram Amar of UC Davis School of Law, called the Legal Foundation's brief brilliant and gripping in SCOTUS blog. Peter will be introducing Thomas Dupree. Peter is also a partner at Smith, Dugan, Cornell, and Golub. He began his career as in-house counsel with GE's Product Liability Insurance Division, then joined Cornell and Golub in 1982. Since becoming a partner in the firm in 1987, he has represented hundreds of domestic and forest corporations and individuals in the state and federal courts of Massachusetts, New Hampshire, Maine, Connecticut, Rhode Island, and Vermont. Mr. Durney also assists major corporate clients in litigation elsewhere in the United States. Chris and Peter, thank you for joining us tonight. I hope you fare better than I do with the AV.
This is high risk. Hello. Oh, that's all right. Nobody's ever said I don't speak loudly enough to be heard in a courtroom, so I guess this is okay. First of all, I want to thank the New England Legal Foundation, in particular Judge Bailey, who I refer to affectionately as Frank since decades ago. I won't tell you how long ago it was. I don't want to step off the cliff right away, but we've been friends ever since. It was many, many years ago. We were law school classmates. No, not that law school. It was a great time back then, and ever since, on occasion, we bumped into each other, and occasionally we've been able to collaborate on presentations. So thanks for allowing us to be here. The short time I have, I want to spend getting right to who I'm responsible for introducing, and that would be Tom Dupree. Tom Dupree and I go back quite a ways. We represented the same corporation for many years, and the corporation was large enough to be able to bring its lawyers periodically, twice a year, to a conference together. And Tom would be the most entertaining spokesperson at that, or presenter. He routinely would tell us all about what was happening at the Supreme Court. And if you are familiar with the type of litigation that we would do, which is mostly products liability and commercial litigation, we don't bump into the Supreme Court that often. We don't get to argue there very frequently. So it was really enlightening because Tom has this gift to be able to bring, to crystallize, to distill the issues in the Supreme Court in these complex cases to a level that I could understand. If I could understand it, then he's done a great job. I think you'll appreciate that this evening. The background that Tom has, and I don't think you have anything about this in the program, so if you'll indulge me, I'll give you a little bit of his bona fides. Tom is the co-managing partner and has been for 10 years or so of Gibson Dunn and Crutcher down in Washington, D.C. Tom has argued more than 100 appeals in the federal courts, including all 13 circuits and the United States Supreme Court. He previously served as the United States in the United States Department of Justice, the DOJ. He was appointed the Deputy Assistant Attorney General for the Civil Division and later became the Principal Deputy Assistant Attorney General. In that capacity, he served as the division's second in command, overseeing more than 900 lawyers in the civil, appellate, commercial, federal programs and tort branches, as well as the Office of Immigration Litigation and the Office of Consumer Litigation. In the private practice, Tom played a substantial role in the successful representation of George W. Bush in Bush v. Gore. He represented the GOAT, our own former Patriots quarterback Tom Brady in Deflategate, and he's had such notable appellate clients as Jerry Seinfeld, Bob Dylan, and Mark Zuckerberg. I've done it before. I can tell you that you can find dozens of YouTube videos where Tom is presenting on in various appearances. His television appearances, it reads like your channel guide for the television. He's appeared on CBS Evening News. He's been on NBC Nightly News, PBS NewsHour, ABC World News Tonight, Good Morning America, MS Now, CNBC, Bloomberg, Court TV, and C-SPAN. He's testified before Congress on constitutional and separation of power issues, including the president's authority to act through executive order, which is about as current as you can possibly get. After revisiting Tom's CV, I couldn't resist asking him, why aren't you on the Supreme Court? His response was, good question, why don't you ask the president? So, before I sit down, I want to share one personal anecdote and introduce another Dupree. The anecdote goes like this. About 10 years ago, I tried a commercial case in Boston, and it involved a CEO of a Fortune 500 company who on his own had invested in a biotech startup, much to his chagrin in the end, because it went belly up, and he wound up being sued as an investor under the Wage Act. And we tried that case. I lost that case. There was a jury verdict, and I turned to my good friend Tom and said, you got to come up from DC and remedy this. He came up, he argued to the Supreme Judicial Court, and we circumvented the Court of Appeals. We went straight to the SJC. The SJC not only vacated the verdict, but they remanded the case for the entry of judgment in favor of our client. It was an incredible, he snatched victory from the jaws of defeat. And finally, the other Dupree. Tom's mom is here. His mother is here, Andrea Dupree. I could read her resume. It would take me longer than it took to read Tom's. And Tom, I'm sure you take no offense to that. Andrea, would you mind raising your hand? Andrea is a distinguished scholar and has a PhD from Harvard and was the youngest female, or the first female, and the youngest director ever appointed director of the Harvard-Smithsonian Center for Astrophysics. She's a remarkable lady. I hope you enjoy the evening, Mrs. Dupree, and without further ado, ladies and gentlemen, I ask that you welcome my good friend, the always entertaining and the very interesting gentleman, Tom Dupree.
Okay. My name is Chris Duggan, and I've been practicing law for 40 years almost, and I have to tell you that one thing I've learned is it is always impossible to follow Peter Durney doing anything, who is my partner over there, which is why I always speak first at partners meetings if I can. I echo his thanks to the Pioneer Foundation, and I am particularly grateful that Frank and your foundation co-authored the brief with me with the Charitable Irish Society in the Trump versus Barber case. It was quite an honor to be on the cover page with Judge Frank Bailey, and it is another honor for me to be speaking to such an august group here today. I don't get this pleasure very often, so thank you very much. It is my distinct pleasure now to say a couple of words about Professor Akhil Reed Amar. Professor Amar is the Sterling Professor of Law and Political Science at Yale University. Professor Amar graduated Yale in 1980. It took a while for him to get his career going, but when he did, he did some good things. He clerked for a judge in the First Circuit after graduating from law school, a guy named Stephen Breyer, Justice Breyer you may have heard of. And then after that, as a result of several law review articles that he had written, finally Professor Amar became a member of the Yale faculty at the ripe old age of 26, where he has served ever since. Professor Amar has the distinction, I think, of being the only living person, anyway, to win all of Yale's three greatest awards, the Sterling Chair for Scholarship, the Divine Medal for Teaching, and the Lamar Award for Alumni Service, sort of like a triple crown, if you will. And he has deserved every single one of them. Now, Professor Amar, I could go on and on about what he has written. He's written hundreds of law review articles, hundreds. Virtually every aspect of the United States Constitution. Where are you, Akhil? With perhaps, oh, there you go. Perhaps the exception of the Third Amendment. Have you ever written anything on the Third Amendment? A little. Okay, great. That's the only thing I know that you haven't written on. He's written 10 or 11 books. All of them have been outstanding books. He's won awards from the ABA. He's won awards from the Federalist Society. He is right now in the middle of he hopes to be a trilogy. I've told him that I think that's a mistake. It really needs 4 volumes of American constitutional history and law. The second volume you have here with you, and please don't leave without getting one signed by Professor Amar over at the table over here for free. The first volume in this service, if you haven't read it yet, it's The Words That Made Us, which is here. And I'm sure that we can get you one of these too. You don't need to read this first to understand everything that goes on there, because one of the many, many things I enjoy about his scholarship and his writing is it's really entertaining, in addition to being extremely thoughtful and very deep. And on top of that, when you get this book, please do. Please start at page 700. It's the most important page in the book, I think, Professor Amar. But he said recently in his second book, the Born Equal, which covers the period, the 80-year period from 1840 to 1920, and hopefully we'll hear a little bit about that today. He said he was asked why the book was so long, and his answer was because his publisher wouldn't let him write a longer one. And the next volume after this is supposed to cover the period from 1920 to the present, but I think there's no way you can cover that in just 700 or 800 pages. So I think we're going to need 4 books, Professor Amar. He has regularly testified at Capitol Hill. He's regularly testified in legislatures across the country. He regularly appears on things like C-SPAN and CNN. And he is one of the few people I know that could say that he appears in the morning on Morning Joe, MSNBC, and in the evening on Fox News. That will tell you about the breadth that Professor Amar has. He has testified on behalf of many people who now sit on the United States Supreme Court. Sometimes he has taken some grief for that. And explained exactly why, and maybe somebody can ask him about why he supported Justice Kavanaugh. And I have to say, we were at the hearing on April 1st on the Trump case, the birthright citizenship case, and when I came out of that, I said, "Oh, thank God we have Brett Kavanaugh here." So, 2 other things I just want to talk about for Professor Amar. The first is one thing among the many, many other things he's done. He was a consultant on West Wing. And in addition to writing all these books, he is absolutely committed to teaching, not just teaching students at Yale, but teaching students all over the United States. I got to know him in 2009 when I was working on a project called the James Otis Lecture that we had started here the year before, and I wanted to do a program called Lincoln and the Law, in honor of Lincoln's 200th birthday. So I wrote to many scholars, and one of them was Professor Amar. And I got an email back within 20 minutes. When and where was the answer. And he and I have done several programs since. The Otis Lecture is one just for high school students, for free. He's never asked me for so much as an honorarium, not a penny. He only asked me to try to distribute his books to foster learning at that age. And that will tell you really more about Professor Amar and his commitment to educating our young people about the value of the constitutional republic we have and the necessity of promoting it and preserving it for the next several generations. So please join me in giving a warm welcome to my good friend, Professor Akhil Reed Amar.
Your mother's first name? Andrea. Okay, we're canceling the program, and Andrea, please come up and take over. She's an actual rocket scientist is here. No, she says no. Okay, fine. I bet you know more about the Supreme Court than I want to thank Peter and Chris, for those introductions. We're going to get right to the program. I do want to say this, though. I have to underscore the Trump v. Barbara case where Chris wrote. We commented on the amicus brief that we filed at the Supreme Court, and we, the Pioneer New England Legal Foundation, got a letter from the General Counsel of the ACLU commending us on that brief, which ought to tell us that we hit a wide swath with that case and with that brief. So thank you, Chris, for your fine work on that. My role right now is limited. I want to say this. So you will have an opportunity to ask questions here. And so what you need to do is there's a sheet on your chair or next to you or now under your chair. It's got a QR code. Put your phone, pick up that QR code, and you'll be able to enter a question. That'll come through on our feed, and I'll see it, and we'll have an opportunity to ask questions, I hope. If you are attending remotely, So you're on the Zoom feed. Just click on the link to the chat to access the form, and you can submit your questions there. And I'll have an opportunity to see those as the evening goes along. But now let's get launched with this review of some of the major cases of the United States Supreme Court in the 25-26 term. And I'm going to start with this, just a simple question. Let's start big here, all right? And we'll go with this. Is this an important term? And what is the importance of this term? Tom, why don't you start us off?
Delighted to. First and foremost, thank you so much to the Pioneer New England Legal Foundation for inviting me. I love talking with people who are interested about the Supreme Court. Delighted to be here tonight, so thank you. The answer to your question is yes, it's an important term. I'm going to go out on a limb and say this is shaping up to be one of the most momentous terms in recent memory. For those of you in this room who, like me, follow the Supreme Court closely, just as baseball fans' pulse rate elevates as the calendar approaches October, for us, we get excited as the calendar approaches the end of June, and the Supreme Court renders its decisions in the cases that we've heard argued and are waiting to hear what the law of the land will be. You can find me on any decision day, right at 10 a.m., sitting, refreshing my browser like mad, trying to find out what decision is going to drop today, and then try to read it and make sense of it very, very quickly. So we're in an exciting time. We're obviously still, a good month or so, or 2 months really away from the end of the term. So a lot of the decisions have yet to come down. But as you'll see from the cases we'll be discussing tonight, I think it's not too much speculation to say that this really is going to shape up to be a memorable blockbuster term, given the importance of the cases that the court is poised to resolve on the merits. If I had to generalize and try to maybe prematurely put a label on this term, at least from my perspective, I think this really could become to be seen as the separation of powers term. I think what you will hear from about a lot of the cases we've discussed tonight, that they implicate really first principles that go back to the founding of our republic, about the proper allocation of power between the three coordinate branches, and how courts are to resolve conflicts between presidential authority, congressional authority, when there are power sharing agreements, when one branch can override another's decision. Those types of fundamental questions are implicated in so many of the cases that we're seeing on the court's docket. Unsurprisingly, I think that's a reflection, number one, of an executive branch that, depending on your perspective, is either properly exercising its Article II constitutional authority or taking us down a short road into despotism. One of the two. But regardless, there's no question that President Trump and his Justice Department have determined the scope in large part of the Supreme Court's docket this year. Many of the cases that the court is poised to decide, particularly the big cases, arise from executive orders issued by the president. So he really has driven the docket this term. So as I said, there's a lot coming down, but at the 30,000-foot level, no surprise, the conservatives, I think, are solidly in control of the court, 6-3, but I think it would be a mistake to assume that those 6 conservatives function as a unified ideological bloc. We've seen many cases, including a case I sense we may be discussing early, where we've seen conservatives take different views. And again, as someone who watches the court carefully and really thinks a lot about it, that's fascinating to see justices who are really applying the same methodology, either originalism, textualism, reaching dramatically different results on some of the most profound questions about our structure of government.
Professor, is it a big term?
Yes, and thank you for inviting me. It's an honor to be with you all. Thanks especially to my dear friend Chris. He's always so modest. He says, I despise a fee, to quote the great James Otis, who argued that writs of assistance case just right down the street here. That I was offered an honorarium, and I say, no, he pays for the books. Okay, that's what he didn't tell you. So these are all his gift to you all, and so please, actually, and he arranged for hosts and others. So. It is a big term. We're going to talk about the cases. I think my friend is just right. President Trump will win, I believe, and will deserve to win a couple of the important cases of the term. But he's already been smacked down big time in the tariff case, one of his trademark policies, and he's, I think, going to lose, and maybe possibly even lose unanimously on the birthright citizenship case, which is another one of his trademark executive orders. And just to put that in context, see, we all in law school are taught judicial review and invalidating acts of Congress. We talked about Marbury versus Madison. The real action in Marbury was actually not so much between John Marshall and the Congress, but between John Marshall and the president, his second cousin, Thomas Jefferson, and they hated each other, and smacking down a president's policies. This doesn't happen very often, especially when a president is like a named party in a lawsuit. And you see two of the cases that we're going to talk about, he's a named party. And so in all of American history, you know, a smackdown of a sitting president on a huge issue of his administration, that would be the Youngstown Steel seizure case. That would be the Nixon tapes case. And we're going to see this twice, I think, this term. We've already seen it once on tariffs, and I think we're going to see it again on birthright citizenship. I think Trump will win at least one other of the cases, the Slaughter case. So big term, separation of powers. Trump looms large. He fills every room. You know, he'd be very happy that we're talking about him. And just so, my friend.
So we'll now dive into the cases a bit, the way I think we'd like to do this is to have your initial commentary about if the case has been decided, was it decided correctly for the right reasons, and if it hasn't been decided, has it so perhaps argued but not decided, then a little prediction: how should it come out? And what's at stake in the case. Is constitutional law a hot issue? I am now teaching undergrads at Boston College in the I'm teaching the constitutional law courses at Boston College, and my course, they opened registration last week, and my course filled up in 15 minutes. So the ones behind us, the ones behind the law students even, you know, are deeply interested in this, and I have nothing. My email box is loading up with people asking, please let me in. Can't you just expand a little more? I said, give me another TA and I'll do that, but otherwise, no. So it's an intensely important time, and that's all about the Supreme Court docket in these famous cases. So you can see we've got a little write-up here. We're going to start with learning resources v. Trump and the companion case, Trump v. VOS selections, the so-called tariffs case. And why don't we start with you again, Tom? Your take on the decision, its importance. Was it correctly decided?
Well, I always feel a little uncomfortable pronouncing whether or not the Supreme Court got it right or not, and that, you know, they're the justices. But in this case, I will say, yes, I think they did get it right.
On the law, we're talking.
So, yeah, and look, I think this was a case when it came up, when the whole Liberation Day occurred. Happy Liberation Day, by the way. It's about a year or so out. I think many of us were shocked. Even those of us who had already grown accustomed to the flurry of executive orders in the first few months of the new Trump administration, I think the sheer scope of the Liberation Day tariffs was, even for President Trump, was big. I mean, he literally imposed tariffs on, I think, not only every nation, but I think literally every geographic formation. There was, I believe, like a rock in the ocean. It was inhabited by penguins. They were tariffed. The penguins were tariffed. And so people said, this is going pretty far. Ultimately, I think it was the scope of that overreach that really was driving the justices who ruled against him. I think if you approach the case from a statutory interpretation perspective, I think they got it right. The administration was relying on, I think, you know, a very thin reed in order to argue that the statute in question, which has, I think, the most magnificent acronym in all of American law, IEPA, the International Economic Emergencies Powers Act, that conferred such a vast, gargantuan, tariffing power on the president was a stretch when you actually look at the statutory text, which simply says that the president can regulate importation. But as the Chief Justice pointed out, those two words, regulate and imports, are separated by about 16 words in the statute. So textually, I think the administration had a very difficult argument to make. Then you layer on top of that the difficulty in the textual argument with just what has become known as kind of the major questions issue. As this group no doubt knows, a few years ago, the Supreme Court either created or discovered the existence of the major questions doctrine, which basically says when Congress purports to delegate very significant, powerful, world-changing authority to the executive branch or to an administrative agency, it needs to speak clearly. That came into play repeatedly during the Biden administration, where the Supreme Court invoked the major questions doctrine to repeatedly cite down examples of Biden overreach, which, in my view, there were many, but it was not shy about invoking that doctrine. And so I think a lot of court observers were curious to say, well, is turnabout fair play? Is the court going to invoke the major questions doctrine against Trump just as it did against Biden? And the answer to that was yes, but partially. One of the most interesting aspects, to me at least, of the slate of opinions that came out in the tariffs decision is that the justices were very sharply split on the major questions doctrine. The Chief Justice, along with Justice Gorsuch and Barrett, basically said major questions, this is a quintessential case, this is no different than Biden's tuition refunds or what have you. Major questions applies. You then had the three liberal justices who did not like the tariffs, but they didn't want to endorse the major questions doctrine. So they wrote separately to say that they reached the same result, that the tariffs were impermissible, but without invoking the major questions doctrine. And then you had the three kind of, I'll say, conservative justices, or at least most supportive of the administration on this issue, who would have upheld the tariffs. What was particularly interesting about all these competing opinions was not just the split on the major questions doctrine and the outcome, but the way that the justices were actually interacting with one another. Justice Gorsuch wrote a concurrence where he actually began by saying, this decision or this case has produced several different camps among the justices. And then he began by saying, I shall now visit each camp and explain why they are wrong. And he did so in that perfect Justice Gorsuch style, somewhat kind of, I don't want to say, pontificating, but he was I mean, you know what I'm talking about, right? It was a wonderfully cogent, arguably paternalistic explanation as to why everyone was wrong. And he had some great points in it. But to me, the case, I think, was not so much surprising on the outcome, but what it tells me is that although they were able to amass 6 votes for invalidating Trump's tariffs, what they weren't able to do is to reach a resolution as to whether or not everyone agrees on the scope and the utility and when the major questions doctrine is properly invoked. So I suspect that will be a recurring question. It would not shock me if their court has another occasion to invoke major questions doctrine in the Trump administration, since many of his executive orders on their face cry out for major question investigation. So I think they will return to this, but for purposes of the tariffs, again, not a surprise. I think the justices recognize they may be creating a major headache for the administration, not just in invalidating the president's signature achievement, but also in terms of having the administration have to process refunds, which I think is going to be extremely complex, extremely hard to do, but that's where we are on the next steps in that case.
Extremely expensive.
Yes, for sure.
Almost impossibly.
For sure.
Yes. Professor Amar?
I think I agree with all of that. Let's just review the policy, which is that President Trump claimed the authority to impose, in effect, any tariff in any amount on any country for any good today, and to change his mind tomorrow, and to change it back the next day. And we're talking about, billions and billions of dollars. That eventually some of those come out of your pockets, our pockets. So that was the power claimed. I think Chief Justice Roberts wrote an outstanding majority opinion. I think Justice Gorsuch wrote maybe what I think is his best opinion yet, and I'm going to tell you what the key moves are. So first, just as a matter of statutory interpretation, what are the words that aren't in the statute? Tariff and tax, and those are magic words. And when Congress wants to give a president tariff power or tax power, as opposed to power to exclude goods altogether for a safety reason or a national security reason, but that's different than tariffs and taxes for a purpose of revenue. Those words weren't there. No congressional statute before this has ever, that didn't use those words, ever authorized a president to impose tariffs and taxes for revenue purposes. So there's a course of dealing between the two branches. Congress knows, these magic words, didn't use them. That's point one. Now, point two, thinking about a broader constitutional context, a fellow once said, I think his name was James Otis, no taxation without representation, and that means the House of Representatives. Now, if they want to give the president power, they can do it clearly, but they didn't do it here. Oh, and so there's a constitutional overlay of this. Charles I got himself beheaded because he imposed taxes without parliamentary authorization. I could go back to the ship money case and petition of right and other things. So there wasn't, so here's the principle, no executive taxation without clear legislative representation. That's just James Otis, just right down the street here, modified a bit. So there's that principle. Now there's another idea, and this appears most prominently in Justice Gorsuch's concurrence. It's connected to major question. It wasn't in, my friend Neil Katyal is going to get all the credit for winning the case, the two Neils, Neil Katyal and Neil Gorsuch. And Neil did a great job, he really did. But actually, in my view, the case was won by an amicus brief. Only one amicus brief actually had the key point that Neil Gorsuch picked up on. It was written by Amar, but not this one, my punky kid brother. Who's a very great law professor. And here's what he said. He said, and Gorsuch picked up on it word for word at oral argument, and so did Amy Coney Barrett, and then Neil leaned into it because he heard, he can count. He had 3 standing on his head, and he only needed 2 more, and this is the thing. If the statute's ambiguous, fine. If you read it to give President Trump the authority to do all of this, and Congress didn't mean that, it can't yank it back. It can't retrieve it. This is called the ratchet problem, the veto problem. If Congress tries to take it back, House will pass a law saying, no, you don't have this power. Senate will agree, and the president will veto it. And you'll need 2/3 of the House and 2/3 of the Senate, and that's very difficult to do. Contrary-wise, if you read the statute more narrowly, this connects to major question and non-delegation and other constitutional principles. If you read it narrowly, and you say, you don't have this power because it doesn't say tax and tariff and taxation representation, and Congress wants to give it to you, it can do that tomorrow. House passes the law, Senate passes the law, President says thank you very much, he signs it. So there's an asymmetry. One, if you do it one way, read it in a pro-presidential way, Congress can't undo it. You read it the other way, Congress wants to undo it, it can easily undo it. And that's at the heart of Gorsuch's very interesting constitutional concurrence.
I was going to say on the Gorsuch thing, the thing that strikes me is that why is it Neil Gorsuch who's having to stand up for kind of congressional prerogative? In other words, in a perfect world, someone in, say, like, Congress might say, hey, wait, this is our power. But it was like during the argument, I remember it was like a magical moment where like the justices were like, wait a second, I just checked the Constitution, this power actually is vested in the Congress. And everyone was like, oh my God. Like I think even people in Congress were like, whoa, we do have this power. But what's interesting is that so much of the debate in that case and in some of the other cases involve situations where Congress has essentially abdicated its constitutionally vested powers, either abdicated them totally or delegated them, or questionably delegated them, to various agencies within the executive branch. So to me, it was telling that it was finally someone standing up for congressional power, but it was someone in the judicial branch, not someone in Congress itself.
All right, we should move to the next one. And but my question to Mrs. Dupree is, do you have more of these at home? What's a birthday party like at your house? I mean, it must be amazing. Anyway, I'm remiss in, by the way, not recognizing my friend Mark Green, Judge Green, Chief Judge Green, recently retired from our state appeals court, where I'm here to tell you that, he introduced a series of reforms at that court. That's where the appeals get decided in this state, right? Which gives the SJC the ability to pick and choose. But his series of reforms made that court really a model of efficiency. So we thank him for coming today, and we mostly thank him for, yes, we do. There he is. Right. But mostly because he's married to Karen Green, who was a partner here, and then a Superior Court judge. So let's move on to Trump versus Barbara, which is the birthright citizenship case. I don't think I need to introduce it more than that to get us started. And Professor Amar, we're interested in your take on the case. It's been argued, hasn't been decided yet. Maybe you could discuss that case first.
Great. And definitely, if you have a moment, read Chris Duggan's brief. The justices actually paid attention to it, and it's an amicus brief. I told you about an amicus brief in the tariff case. This is an important amicus brief that they took very seriously. I wrote an amicus brief as well. You might want to take a look at it if you're at all interested. I have a series of SCOTUS blog columns on this throughout the month of March. And just in a nutshell, here's, and if you want to see just bottom line what happened at oral argument, and Chris was there and I was there. There was a fellow named Trump who was also there, first time in American history that a sitting president attended an oral argument. But if you just could look at one thing, I have a SCOTUS blog column on April 13th in which I go through the oral argument, quote each of the justices, and then show you parallel passages in my brief or in earlier SCOTUS blog columns. I think that they, frankly, were in line with what I was arguing, which is in part based on what they have said before and what the Constitution actually does say. So I think I counted easily 7 votes for my side, maybe 9, possibly, because there's a statute as well as the constitutional provision. But just here's the point. All persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay? So you're going to say, well, what does that subject to the jurisdiction mean? And it means under the flag. Subject to is under, jurisdiction is flag. There were some exceptions. If you're born on Indian land, there's a different flag that flies over that quasi-sovereign entity. If you're born on a foreign warship that's flying a different flag, that's flying the Mississippi or something, that's different. If you're born behind enemy lines where there's a military occupation, the Brits occupied part of Maine in the War of 1812, Americans occupied part of Mexico, the Mexican-American War, the Allies occupied part of Germany after World War II, then it's a different flag that flies. Born on the soil and under the flag, that's what the Republicans said again and again and again. That's clean. Now, if it's about who your daddy is or your mommy, first of all, why didn't they say parent? And if it is parent, which one? Okay, because you have 2 ordinarily. And slavery descends through the mother. People born overseas to American citizens, it actually descends to the father. That's an 1855 statute. And no one specified any of that in the text or in the legislative history. Oh, my friend Neil Gorsuch asked just that question. Well, which is it? Okay. And what do you do with orphans? Foundlings, baby Moses, Tom Jones, if you're a Henry Fielding fan, or Oliver Twist. And it's not about your parents. That's what this book is all about, okay? And either I'm full of it, or I actually know what I'm talking about. That 800-page book is about a profound Lincolnian idea, riffing on the Declaration of Independence, but modifying it. We're created equal. okay? And he says the 14th Amendment uses the word born. You're born an equal citizen. They don't say race, they could have said race. You're born an equal citizen whether you're born black or white, male or female, Jew or Gentile, in wedlock or out, whether your parents are citizens when you're born or not. My parents weren't citizens when I'm born. They were here legally. The United States government invited them to actually they're doctors saving American lives. But it doesn't matter. If you're born on the soil and under the flag, you're an American citizen. All the members of the congressional Republicans at the time understood this. Read the brief, lots of historical evidence, but just read the words for yourself. No administration ever took a position remotely like this. Even Trump 1 didn't do anything like this, ever. All three branches for 150 years, and there's a statute in 1952. If that doesn't persuade you, there's a statute that actually says really clearly this. And other provisions of that statute talk about, for other configurations, if your mother is this, if your father is that, if you're a foundling and we don't know who your parents are, and all the rest. So even the justices who might not agree with me on the statute, I think I have I have some hope that Justice Alito and Justice Thomas, who are both pretty close friends of mine, will at least be open to this argument. Maybe I lose, but I think they're going to read the brief if they haven't done so already. And I think if you read the brief and you're, what's the word I'm looking for, a lawyer, or a judge, what's the word I'm looking for, it's actually not a close question. That's what I, in fact, believe. So we will see, but I'm making a very bold prediction here, in front of you all, that I think there are at least 7 votes for this, possibly in result 9, especially when you bring in the statute and the gloss on the statutes by cases old and new, whether we talk about a case called Wong Kim Ark from the 1890s, or a case that you've never heard of before, but is absolutely decisive, called Antopolis. I'll end telling you the facts of Antopolis. Okay, and no one was talking about Antopolis. It's in our amicus brief. Justice Sotomayor asked about it, 1957. Here are the facts. A woman comes and overstays and pops out a kid. And her husband comes, overstays, pops out a kid. And from today's perspective, it's an anchor baby, and she's a birth tourist, and they were here illegally. They're illegal aliens. They actually didn't tell the INS, and then they actually said, because the kid's an American, it'd be a hardship for us to leave, so let us stay because the kid's an American. And wow, you might think that's despotic. The justices unanimously said the child is, of course, an American citizen. And that was the position of the Solicitor General. It was the position of the INS. Every single justice took this position. It was the assumption of all the justices in this case. The question in the case was, because the kid is born on American soil and is, of course, an American citizen, does that mean the parents get to stay? And 2 say, yes. Okay, and the other 7 say, no, the executive department can decide, and we defer to their decision. So, wow. All
right, we're going to, here we go. We are going to, we could listen to you a lot longer. At least I could. This is really fascinating. But Tom, do you have a different view of the case that you would like to articulate?
There, historically, I think, have been fewer principles more embedded in the American creed and the Constitution and the concept of birthright citizenship. And so I think that is why when the president issued his executive order purporting to revoke birthright citizenship, it caused a stir. I think a lot of people were surprised. I think some people probably weren't so surprised. They say, well, of course, he's said as a policy matter that he doesn't think this makes sense. And frankly, a lot of Americans, as a policy matter, I think agree with him that birthright citizenship doesn't make any sense. But if you are a lawyer in the Justice Department who is tasked with going into federal court and arguing that, in fact, President Trump's interpretation of the 14th Amendment is the correct one, you face some headwinds. And that's what happened in the first I don't know, 1, 2, 3, however many cases, test cases or challenges to this as they got litigated in the various courts. The administration's lawyers were met with anywhere from, ridicule to outrage. I mean, look, I think he actually had a better track record in challenging the 2020 election results in various courts than he did in the birthright citizenship, right? I don't think he won any of the birthright citizenship. He did win some of the election, like 1 or 2.
You're right.
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 So better record there, which tells you something. So when this case went into the Supreme Court, everyone, myself included, thought, not a chance, not a chance. But I will say this. I agree that the justices are certain to strike down the executive order. I would be beyond shocked if there were 5 justices who were willing to uphold it and renounce birthright citizenship. But at the same time, I will say I found the administration made a far more compelling case than I thought they were going to be able to make when I read the briefs and I listened to the argument. 2 things jumped out at me. One, what was somewhat amusing during the argument is the administration, the Solicitor General, was arguing that, look, things have changed since the 14th Amendment was enacted. We have all sorts of things. We have obviously a massively higher immigration rate, the complexion, the constituencies have changed in terms of the percentages of native-born Americans versus immigrants. There are new problems that have manifested, the so-called birth tourism problem. So it's a different world. And that argument was met with one of the Chief Justice's great, typical wry ripostes, which I'm sure, I don't know if he comes up with these in advance. Do you know if he does? But it's like, no one can be that clever on the spot, right? So he said, and the Solicitor General was saying, it's a different world, it's a different world. The Chief Justice dryly remarks, different world, same constitution. And everyone, the media went crazy, as they should, because it was very clever. But what it said to me was it's kind of ironic that it is the Solicitor General and the Trump administration that is urging the kind of evolving Constitution, that the principles in the Constitution change over time to reflect, liberal, change circumstances. You have to take a liberal approach to constitutional interpretation. Kind of where I come from, that is not the conservative position, right? That is not. But yet that was the argument the Solicitor General made. Number 2, and I know you will appreciate this, the Solicitor General relied on arguably the greatest, or one of the greatest bête noirs of the entire conservative legal movement, Justice Breyer, because he was saying, look at the practices of other nations. They reject birthright citizenship. Of course, it was Justice Breyer who, this was his whole thing. He wrote a book on it. It did not hit the top of the Amazon charts, but I thought made a reasonably cogent argument for why in interpreting American constitutional law, you need to look at the practices of other nations. I don't buy that argument at all, sorry, but the Solicitor General, the Solicitor General had to make that argument. So here he is, throwing originalism in the trash heap, citing Justice Breyer. I'm like, my God, where are my conservative friends up there? So look, at the end of the day, I think they're going to lose. They made a much better argument than I think they did. I would actually be a little surprised, maybe not, you may see it differently, if they went to the constitutional question, given just the rule of constitutional avoidance. Why, I think Justice Kavanaugh made this point. He said, why do we have to reach the constitutional question if the statute mirrors the language of the 14th Amendment and we can resolve the case on statutory grounds, which also would have the effect of basically kind of putting the hot potato in the lap of Congress, which, as we all know, will never do anything. So.
Okay, let's move on to Trump v. Cook County and a companion case, Trump versus Slaughter. We have a brief description of those cases, but Tom, why don't you pick up and continue and give us some background on these cases.
Sure. Well, these are the cases that concern the president's authority to fire members of the so-called independent agencies. The case involving Cook she's one of the members of the Board of Governors of the Federal Reserve. Slaughter is a member of the Federal Trade Commission. The 2 cases came up roughly at the same time. They are argued separately. They haven't been consolidated, and they present slightly different issues. But both really do center on the power of the president to basically jettison the heads of these so-called independent agencies, regardless of whatever constraints Congress may have placed on the president's removal power. These cases, I think, have really been inevitable, at least from my perspective. Is those of you who kind of follow the exciting world of administrative law know that back in the New Deal era, the Supreme Court decided a case called Humphrey's Executor, which, not to like cause, ad law PTSD in this group, but that was the case that basically said independent agencies are a thing, and that Congress can, consistent with separation of powers and the president's authority to run the executive branch, can place certain restraints on these independent agencies. In fact, it is those restraints from termination that confer the label independent on independent agencies. Why are they independent? Well, because the heads can, act without fear that, the president will just swap them out on a whim. That's what gives them their independence. Now, of course, I think thoughtful people started questioning just the legitimacy and the very concept of independent agencies. If you read our Constitution literally, which we should do, it provides for 3 branches. It's a fish or fowl. It's either Article 1, it's Article 2, or it's Article 3. Where does an independent agency fit in? It's not in Article 4, and then we know that it's not in 1, 2, or 3. So it's got to be somewhere. And so this insight really manifested itself in the idea, the concept of this so-called unitary executive theory, the idea that the president is the head of the executive branch, all Article 2 executive power that is exercised in the United States is under his domain, his auspices, and Congress cannot constitutionally place any sort of restraints or limits on the president's decision as to who will execute these powers of the heads of these agencies. Humphrey's Executor has been chipped away and whittled away over the years. It got to the point where, I remember it was Justice Kagan or someone at one point a term or two ago kind of looked around the room and said, have we actually overruled Humphrey's Executor? It kind of feels like we have, but she wasn't sure. The court has never actually taken the final step and overruled it. In many respects, I think Humphrey's Executor occupies a similar place in the judicial firmament as Chevron did, where we all knew Chevron was going to get overruled, and there were various cases where the court granted, and we thought, this is the one, this is the one. And then it was like, Lucy pulling the football away from Charlie Brown at the last minute, and Chevron survived. Humphrey's Executor operates in a similar place. It has been whittled away, it has been limited, it has been restricted, and I think many people, myself included, think that there is a very good chance that they will overrule it this term. The Chief Justice during argument referred to Humphrey's Executor as a dried husk, which if you're a defender of that decision, those aren't good words. You don't want to hear that, right? You don't want to hear that saying, this thing is useless, no one can rely on it. Now, that said, I think the big question, at least for those of us who follow kind of the ins and outs of Washington, is assuming, as I think they will, the court will say, at least in the Slaughter, the FTC case, that the president can fire an FTC member for anything, no restrictions, whenever they want, it's basically at will. If they rule that way, under what principled basis does that not apply to what everyone really cares about, which are the members of the Fed? That's what's going on here. And it's difficult to articulate I can think of some arguments, why the Fed would be different from, the FTC or other independent agencies. And there's definitely a flavor of that in a lot of the arguments. The word, unique kept coming up. It's occupied a unique place in our history. It's a unique tradition of the Fed and the importance of the Fed. It's not a satisfying answer, I think, to those purists out there who take kind of a purist view of the concept of the unitary executive to kind of say, well, there's this Fed exception that fits into our nation's history because the Fed is really important. I'm not quite sure how they solve that. Candidly, I've always thought that at the last minute, the chief will come up with some rabbit out of the hat, the Obamacare is a tax, not a fee sort of solution that, kind of amazes everyone and infuriates others. So I do think at the end of the day, they are going to overrule Humphrey's Executor. I do think they are going to eliminate virtually all restrictions that Congress tries to place on the president to remove these people. But I do think they are going to find some way to carve out an exception for the Federal Reserve.
Professor?
I agree with most of that, almost all of that. So the Constitution talks about appointment, but not disappointment, so to speak, removal. So why is it obvious to all of us, 9-0, that presidents can fire cabinet officers at will, secretaries of defense or war, whatever you want to call it, secretaries of state, secretaries of the Treasury? That's 9-0. Where does that come from? The Constitution doesn't say. If you read the Federal 77, actually, Hamilton says you're going to need to sentence agreement to remove someone, which is not our practice at all. We call that a legislative veto. And the answer, which you'll get in The Words That Made Us and some other long books that I've written, is the Washington administration. A lot of what George Washington did glossed actually the Constitution. And under a thing called the Decision of 1789, it was established, part because Washington insisted on it and the first Congress agreed, that Washington can fire cabinet officers at will, heads of departments. So then the question is, well, where do these independent agencies come from at all? And one thought is, well, individual heads of departments are different than multi-member boards, and there's some other possible distinctions. So, cards on the table. So Becca Slaughter is going to lose. I say Becca, she was my former assistant, you know, and here's why she's going to lose. Because what she's doing really isn't very different, and Lena Khan and others, from what the antitrust division of the Justice Department does, you know, with mergers and other things. And the president can fire the head of the civil division and the head of the antitrust.
I got fired by Obama, so
Okay.
just so you know.
Okay.
I'm over it. But,
I feel your pain. He nominated me for something and I never even got a hearing, but we're not going to go into that. Okay. So, and they're not scientific experts. I love her, but she doesn't have a PhD. They're just making policy. So it's possible that she loses and Humphrey's executor is distinguished on its facts rather than just overruled, saying today's FTC is really different than the FTC in 1935 when they were scientific experts, but she's going to lose. And then the question is, because we judge a president by overwhelmingly how she or he handles the economy, you know, mergers and all the, and whether you approve Spirit Airlines, you know, proposed merger with a JetBlue or not. Wow, that's going to have consequences for jobs and all the rest. Just saying, Elizabeth Warren. See, I'm skeptical of this. So, if he's going to be judged by this, then he should have his people. And that's one version of unitary executive. Then my friend says, well, what about the Federal Reserve? And he said, what distinction are you going to have? And I'm going to give you 4 rabbits, because they will distinct. So, and he thought that tax thing in Obamacare was rabbit. I actually originated that idea long before actually John Roberts agreed with it. So, it's actually in the Constitution, taxes. We talked about that with the IEPA case, the tariff case. Here are the 4 possible distinctions. So, really 5. One is because your 401ks depend on it, and so do the justices, so done. Connected to that, the administration didn't even challenge the statute. The Constitution has a statute that says, they can't be removed except for good cause. So that's not even in play, okay? And they did challenge the statute in the FTC case. What might make it different? Why might they not? One, because they don't quite enforce the law. They set interest rates, and that's different than law execution. Second, because they do things that are quasi-private. Some of the governors of the Federal Reserve in the system actually are private bankers, and that's a little different. And the third rabbit, these are the rabbits, they're going to work backwards from the 401k, and so these are the rabbits that, that they might mention. Back to George Washington. It was clear at the very beginning that he can fire the Treasury Secretary, Alexander Hamilton, my name is Alexander Hamilton, at will, and the AG, and Secretary of War, and the Secretary of State, but he couldn't fire everyone in the first bank. He couldn't fire everyone in a thing called the sinking fund. And arguably, the sinking fund and the first bank are analogous to the Fed. So yes, there's the decision of 1789. You can fire people who are like the Attorney General. That includes people in the antitrust division and the FTC. But the decision of 1790 and of 1791 on the bank and the sinking fund mean that actually, when it comes to the economy, in certain respects, you can create things that limit presidential removal power. Those are the rabbits.
All right, we're going to move to a lightning round now because there's so much more that we could talk about on these remaining cases. But I also have a couple of excellent questions. So you know what? I think with your so Wofford versus Lopez is the Second Amendment case. There's a lot to say about guns and this court. United States versus Chattree is the geofencing warrant case. Fascinating, a little outside of our purview here at Pioneer, but a lot could be said about it. But let me ask questions, and then we'll see if we can come back. All right, the first question is this. I'll read it just this way, all right? I'm curious to hear your thoughts on, and I think this is mostly directed to you, Professor, but on the recent New York Times story about the origins of the so-called shadow docket. First, a little about the expanded willingness to grant emergency relief with explanation and unlimited record and procedural development. But, question, as a former law clerk, what does it mean and how does it happen that those memos find their way into the hands of a Times reporter?
The leak issue.
Two issues.
Well, the leak issue is from something 10 years ago, so it could even be a justice's papers. So it's not like a Dobbs leak of a yet-to-be announced decision. So on the merits of the thing, yeah, I am implicated in all sorts of ways. So Beckett is my former assistant. So is Will Bode, who coined the phrase shadow docket. Another student who wrote a book called The Shadow Docket with Will's permission is yet another one of my former students, Steve Vladeck. I'm with Will and not with Steve. I'm closer to Michael McConnell. I think basically when the lower courts are not in line with the Supreme Court can jump in early, take a peek at the merits, and decide what the status quo should be while the case is percolating up. And you might say, well, they don't really have full briefing and all the rest. 2 or 3 quick points. One, there has to be a status quo in the interim, and why not be the one that the court, at least now, thinks will be the one that will eventually think is the correct one. This is likelihood of success on the merits. And judges do that all the time. They make preliminary, they peek at the merits on TROs, preliminary injunctions. So, and a lot of these issues, the justices aren't looking at it for the first time. They thought about Humphrey's executor 5 times before, and all the rest. They've had full briefing on it. So I am not a critic of the shadow docket the way Ketanji Brown Jackson is, and Steve Vladeck is. I'm more on the side of Will Bode, who is a conservative, Michael McConnell, who is a conservative. The Supreme Court is more conservative than many of the courts below, and they're trying to rein them in. Oh, but I predict that my friend Steve Vladeck is going to be very happy when the Supreme Court shadow docket, like this is just this week, actually puts on hold a Fifth Circuit decision, which is way to the right. This is on the mifepristone and chemical abortion stuff. And so you asked 2 questions on leaks. This is not like Dobbs, because this is from the 2016 year or term. That was a long time ago. Could even be a justice's papers or something that are in some custody. And on shadow docket, I'm basically with the court. I think what they're doing has not been actually judicially inappropriate. It's part of a judicial hierarchy in which they're supreme and other judges are on inferior courts.
Tom, shadow docket.
Well, first on the memo leak, I am outraged and infuriated at that leak. The Dobbs leak, I take the point that was obviously a merits opinion. These are, decade-old memoranda, so there's that difference. But from my perspective, I don't see how a court, Supreme Court, let alone any court, can function if it believes or has reason to suspect that what it thinks are internal confidential deliberative memoranda are going to be released to the public, and in this case, what appear to be just for transparently, partisan political purposes. I mean, whoever leaked those was clearly trying to do so in a way to impugn the court for, its use of the shadow docket, its increased reliance on the shadow docket. So, I'm not quite sure what the solution is because, again, these are, decade-old memos, and so there's a universe of suspects. And, as we saw from the Dobbs leak, I don't think the Supreme Court's Marshal's office is necessarily going to, be able to figure this one out. But to me, that the leaking aspect of this is beyond infuriating. On the use of the shadow docket, I think the Supreme Court gets a bum rap for that. I would also point out that the Trump administration has been far, far, far more active in seeking this interim emergency relief than any prior administration. I think Biden went on kind of the shadow docket, I think something like twice in his first year. Trump did it like 25 times. Back in the Bush administration, we never would have dreamed of doing this. Like, impose on the justices? No, we can't do this. Like, so quaint now, but that was the way we thought. Trump is not as shy, but you look at the track record of success the administration has had. They've won, I think, like 23 out of 25. You can't blame them for using a litigation strategy that works.
It's not on our list, but someone does ask a question that is highly pertinent to the work of the New England Legal Foundation, Pioneer NELF, and that has to do with education choice issues. We're really not going down the gender disputes that we see, but we certainly do go down the road of concern for families that wish to choose a religious school for their children, but not receive all the benefits that state offers to other children, and therefore interferes with their ability to go to those schools. We wrote a brief in the St. Mary's case out of Colorado. We will file a merits brief that cert was granted in that case. I haven't asked you before, but I'll ask you now, each of you, does the Espinoza, Carson movement, if you're familiar with those cases, I suspect you are, does that plod forward now with this court, maybe even with greater vigor? That's my question.
And this is connected to Smith. So I have always believed that religious private schools should not be treated worse than non-religious private schools. So the key idea is not separation as such, but not separate but equal. And so is it possible for government money to find its way into a church coffer? Sure. I get my Social Security check, I endorse it over to the government, over to my church, I drop it in the collection plate. That was my free choice. So, and that's, the Supreme Court has basically said, in effect in some of these voucher cases, that they're not unconstitutional for the religious school that teaches reading, writing, arithmetic. It should get the same benefits as a non-religious private school that teaches reading, writing, arithmetic. And you can require a school, as a matter of accreditation, to also teach evolution and science and all sorts of things. The theory of human speciation by natural selection, all fine. Now, the Colorado case is a little different because actually the policy of Colorado is not singling out religious schools as such for discrimination. It's a slightly different thing. And Colorado and the school is saying, we have just a policy of not admitting children whose parents are gay. And in general, you say, well, you might have all sorts of policies of not teaching evolution or not teaching math, and you can have those policies, but then maybe you just aren't eligible for the voucher. It's a general, neutral, secular criteria. The problem is it's Colorado, and Colorado actually has a bad track record of actually animus against religious entities. That was a case involving a baker, Masterpiece cake, and a case involving a software designer, Creative 303. So the case is going to actually come down to, I think, specific facts. On the one hand, Colorado hasn't treated religions very well, and some people who work for the Colorado government have said some genuinely stupid and anti-religious things. On the other hand, the policy on its face is general and neutral, and some justices are going to say, why are you punishing the kid? Because their parents are gay. You know, would you demand eligibility for the voucher even if you say no blacks? But that's next term. And I know you're involved in the case, and I'll read your briefs with great interest.
Okay.
And I have not read the briefs, and I don't have much to add other than to say that if you say with this current court you've got Colorado on one side and free exercise on the other, I know which one I'm betting on. So.
And just for the record, I was against Colorado for reasons of religious equality in both Master of Peace Cake with Neil Gorsuch and not with my friend Elena Kagan and Creative 303.
And has the court effectively overruled Smith? Aren't there 5 justices that have said Smith should be overruled, but they haven't said it in the same case? Sorry for this inside baseball stuff.
Well, I think Justice Barrett, who clerked for Justice Scalia, who authored the Smith case, is cautious, and she's a little worried about just how big Pandora's box is if she opens it, and what will come out. So I think in cases like Fulton and others, she's expressed some hesitation.
I agree with that. I mean, Justice Barrett in her confirmation hearing, you'll recall, number one, she was pressed obviously on her religious views, but the other thing that really struck me is when she was pressed on whether or not she would allow her religious views to dictate outcomes in cases, I thought she had the perfect response where she kind of sidestepped it all and she said, in my bones, I am just a law professor. And that, to me, I think really speaks volumes, and that is the way she has conducted herself on the court. In other words, she doesn't write in sweeping ideological terms. She really is a thoughtful, takes almost an academic approach, like the professor she was, to these types of cases. So I think that explanation is plausible.
And if you want to see that best of, I think Gorsuch's opinion in the Terrace case is maybe his best opinion, and it's very ambitious. Her performance at oral argument in the birthright citizenship, Trump versus Barber case, was spectacular. It's the best I've ever seen her, and it was pure law professor, Socratic, questioning, and I loved it. So if you're at all interested, don't read the transcript, listen to the tape of Justice Barrett, especially actually with Cecilia Wang, but I loved it.
Well, I think we are at the end. I have the dubious honor of probably being the only one in the room who actually had a case go to the U.S. Supreme Court, and I was reversed 8-1. So Justice Gorsuch, it involved Indian rights, right? So Justice Gorsuch was on my side, and I think he's brilliant. So my vote is for him to be the next chief. But I want to thank you both so much for your being here tonight. Okay, the bar is open again. Please enjoy yourselves. We thank you so much for coming tonight. Oh, hold on. I want to say a little more than that. All right. I'll finish it with this. Again, this is the 4th time we've had this event, and we call it Reasonable Minds Can Differ. And when it comes to the Supreme Court cases of the term, it seems as if on the law, we're not getting a whole lot of difference in terms of where people sit on the political spectrum. But we keep inviting people that are focused on the law, which is why I suspect we keep having this kind of discussion. But what we need to focus on, I think, tonight is that civil discourse is possible. And we certainly see that here. I don't think these guys agree on everything, but you wouldn't know it from the way that they conducted themselves, right, tonight. We know that that's important, and that is what we at the Pioneer NELF are dedicated to. We thank you for coming tonight. We thank you for your support. You'll be hearing from us again and again about support, and we hope that we can fit into your plans as far as that is concerned. But most of all, thank you for coming tonight.